Appearances?
Good morning, Your Honor. Lisa Szyc, 11726 on behalf of and third-party defendant Lisa Fessler.
Good morning, Your Honor. Molly Rosenblum, bar number 8242 on behalf of the defendant Jason Fessler. He's present.
It's plaintiff, third-party defendant's motion to dismiss defendant, third-party plaintiff's third-party complaint with prejudice pursuant to NRCP 12B5.
May I please support? Your Honor, most of the argument is set forth in the briefing. Just briefly, I would like to address points that were raised in defendant's opposition. It does appear from the opposition that Mr. Fessler is addressing the substantive issues of the case and not the procedural aspects of the case. It appears that he is attempting to assert a standing issue. Essentially, that he has the position to assert a negligent argument on behalf of plaintiff against Aluna, and I believe that claim fails. He has cited no legal authority that permits a perpetrator of a sexual assault to step into the shoes of their victim to bring forth a claim of negligence against the victim, so that's concerning. As you are aware, standing as an argument that there has to be a causal connection. So then Mr. Fessler has not made that connection with respect to his negligence claim. So he did not suffer any personal damages in making that claim. And so I would ask that that claim be dismissed as to Aluna. And with respect to the indemnity and the contribution claims, there's an overwhelming public policy as to why those claims should be dismissed. And I understand that his position is that the case that I argued in my brief is persuasive and non-binding because it's from Pennsylvania. There is no direct case law in Nevada on the issue of a criminal actor seeking indemnification or contribution for his acts. But in almost every sister state, there is case law that says that that notion is preposterous, and it dates almost back to common law. And if you go into the cases that are cited in the Gennardo case that I relied on and go further, there's extensive history on that. And there is relied that the idea that the notion that a criminal can seek indemnity or contribution for their criminal act, it belies logic. And Mr. Fessler further did not cite to any case law or statute or authority that would allow him to seek indemnity or contribution for his criminal acts. So unless the court has any specific questions, I would submit it on that argument and the briefing.
Okay, response.
Thank you.
Morning, Your Honor. This is the third-party defendant's motion to dismiss. The court's aware of the standard on motion to dismiss. It's whether the complaint states claim for relief. It remains our position that the complaint adequately states claim for relief against Aluna Fessler. The case law, as counsel's noted, is from other jurisdictions. There's no direct case law in the state of Nevada that states that Mr. Fessler cannot bring a third-party complaint against Ms. Fessler. Essentially, what the plaintiff's motion is an end run in an attempt to obtain summary judgment. The facts in the case, while the court and counsel may not like them, lend themselves to a decision by the trier of fact and not based on a motion for dismissal. And so that remains our position, Your Honor. It's submitted on that.
Right. Thank you. Last word.
Well, I would respectfully disagree with counsel's argument that this is a summary judgment standard. As noted in the briefing, Your Honor has the ability to take notice of orders, judgments, matters of public policy, and making a decision on a 12B5 and a 12B6 motion, which is exactly what I've asked you to do. I've not asked you to seek any facts that were not alleged in the complaint or in an order or outside of an order or anything in which you could take public notice of. Mr. Fessler made admissions, Mr. Fessler set forth allegations, and quite frankly, we don't need to necessarily argue the substantive nature of the case to make a decision as to this particular motion to dismiss, because essentially it's procedural. The question, it becomes an issue of standing. Is it appropriate for him to assert a negligence claim against his victim of sexual assault? The answer there, or against the mother of his victim of sexual assault, the answer there should be an astounding no. And further, then the question of should he be allowed to seek indemnity or contribution for his criminal acts? And the answer there should also be an astounding no. And on that, I would submit it.
All right, all things considered, I'm going to deny the motion without prejudice to further development. I think it'd be better framed and treated on a motion for summary judgment than on a motion to dismiss. As I read the third party complaint, it appears to me that there are allegations made that can withstand the 12B5 aspect, 12B5 motion that is what's before the court today. So that's the feeling. As I read the third party complaint, it alleges facts that appear to me, for example, on paragraph 9, on October 9, 2022, third-party defendant knew or should have known of risks of plaintiff safety, including third-party plaintiff's history of sexual addiction, plaintiff's vulnerabilities as a minor with a history of consuming alcohol and drugs, both with and without third-party defendant's knowledge. Third-party defendant was aware of the presence of alcohol and or drugs at the residence where plaintiff and third-party plaintiff had access to them, creating an environment where harm to plaintiff became foreseeable. Third-party defendant, paragraph 11, third-party defendant was present in the home on the evening of the incident, but failed to intervene or ensure plaintiff's safety despite signs of intoxication and alleged coercive behavior involving third-party plaintiff. So in any event, I can't, I don't think it's proper for me to address this in the context of 12B5. That's without prejudice to further development. Okay, so I need a proposed order.
I'll present.
By counsel. Okay.
Thank you.
Thank you, Your Honor.
Thank you.